The former president of the Nigeria Bar Association, Olisa Agbakoba, a senior advocate of Nigeria. Good morning and thanks for joining us. A whole lot has been happening concerning this matter. That let's look towards the CCB as a bureau and even the CCT to have a better understanding of what it is about. Tell us the act establishing the CCB to start with for better understanding.
Yeah, before I do that, let me set the political context.
For the establishment of...
No, there's a context
of what's happening.
There's a context playing out. The context is we have a left-of-center government. That's the APC. That is inclusive. That has displaced the PDP, which was a right-of-center government, which was corporatist and elitist. So what's playing out now is what has also played out in America. So let's be very clear that this issue of Saraki, whether it's guilty or not guilty, is part of the political change that comes when one government goes in and another comes in. So that's an important context. In relation to what's playing out, I do not want to constitute myself into a judge here. As you know, the matter is before the Federal High Court. It's also before the Code of Conduct Tribunal. So what I think will be of benefit today is to discuss some basic principles and concepts, if you don't mind. There are only two kinds of courts in Nigeria. One is referred to as superior courts of record, prescribed and consecrated by Section 6 of the Constitution. And they are named. You can check it if you want to. Others are referred to as inferior courts. And a Supreme Court decision says no matter how you clothe this inferior court with jurisdiction, it remains an inferior court. Therefore, the Court Martial is an inferior court. The Code of Conduct Bureau is an inferior court. The old National Industrial Court, if you remember, was an inferior court until President Adejumor worked very hard to pass the third amendment to the Constitution that elevated the court to the superior court. I have sat in the NJC for 5 years. I have never seen Justice Umar. I've never seen him.
Before you continue, very quickly, what's the right nomenclature for those who had such tribunal? For instance, the CCT, because
they are not judges.
So it's absolutely incorrect for anyone to refer to the chairman
they're not judges.
As a justice.
Absolutely. The other lady, who is my very good friend and classmate, the chairperson of the Investments and Securities Tribunal, is referred to by nomenclature as the chief judge of the IST. But it's just the chairperson. So I think that's the confusion. Now, the move by Saraki, and to be honest with you, I have no interest in whether Saraki goes to jail or not. It doesn't concern me. Nobody's above the law. So that's not the point. But the point is that things must be done lawfully. So if a person has not declared his assets, there's a procedure to follow. So Saraki's case, rightly or wrongly, but that is his case, is that the process by which he has been brought before the CCT is wrong, and that he has approached the Federal High Court to have the issues reviewed. The other argument is that if you feel that there's a problem with the way in which we have charged you before the CCT, come before the CCT and say so. That's the issue. But Saraki is right. There is something referred to as the power to judicially review administrative actions. Remember that the CCT has taken no decision. If the CCT were to take a decision on the merits of the case before it, then the channel of grievance for Saraki would be the Court of Appeal. So if you went before the IST, which is the same as the CCT, just that it's working in the capital market, and you are aggrieved about something, and the IST made a ruling on the merits of the grievance that has been brought against you, the proper venue is the Court of Appeal. I have represented numerous clients. I have represented clients who have gone before the IST to complain. We preempt them by telling the IST that there is something irregular in the way the charge has been laid. And we now go to the Federal High Court or the State High Court. These are the two bulwarks of the Superior Courts of Record to have it reviewed. So I want to say very clearly that the CCT has not started proceedings. The case Saraki is making is that the manner in which the Attorney General's office has laid the charge before the CCT is irregular.
So do you agree with that? I mean, that
I do.
First of all,
I do.
You cannot institute criminal proceedings unless there's a sitting Attorney General.
No, I won't go into that because that is not, I'm not Saraki's lawyer, but I'm just setting out the procedure. The procedure by which Saraki has been charged, according to Saraki, is defective. So what should he do? Should he go before the CCT to make a complaint, or should he go to the Federal High Court to make a complaint? That's the broader issue.
Yeah, but what's up with the manner in which he's been charged?
Yeah, no, I'm not sure I follow you.
You talked about the procedure, you know, the channel.
Yes.
How he was charged.
Yes.
What is wrong with it?
Yeah, you see, I want to be careful not to sound like Saraki's lawyer. So that is the work of my good friend J.B. Daudu. So I'm discussing principles. So I'm saying the Attorney General has the power to lay a charge. There's no question. But the Attorney General must lay the charge properly. If he fails to lay the charge properly, the question arises, which court would the aggrieved person go to, like Saraki? Should he go to the Federal High Court to complain about the manner in which the charge has been laid? Or should he go before the Code of Conduct Tribunal to say there's something wrong with the charge? You know what I'm saying? Because the manner in which a charge is laid is administrative. The court to go to is the Federal High Court, because the Federal High Court possesses the power to judicially review administrative action, not the CCT.
Now, quite a number of people, you know, because the charge sheet is already in public space.
Yes.
Quite a number of mediums have obtained it.
Yes.
And, you know, they've disseminated it. And I'm sure a lot of lay people would have read it.
Yes.
The question is, they might not understand.
Yes.
And if these are some of the things that are coming to the fore,
yes,
then perhaps we should have an understanding of what that could mean. I mean, you've done many cases in terms of procedure or presenting. It might be a little bit technical,
yes,
but at least it might help if they understand a little bit in terms of procedure of presenting charges. The
procedure of presenting charges is just to drop something that, you know, clearly conforms to an offense. So the offense generally here is relating to Saraki's manner of declaring his assets. He has not declared it in a way that the Attorney General feels satisfied. But the first problem is there's no Attorney General. There isn't an Attorney General who will direct Mr. Hassan to bring the charge before the Code of Conduct Tribunal. So there's a problem with that. But apart from that, we return to the general principle that the clash between the two courts seems to be an issue. And that is because of a misunderstanding of the nature of courts. There are only two kinds of courts in Nigeria. And I've said one is the Superior Court of Record, prescribed by Section 6. And they are named there. And they are given unlimited jurisdiction. So this nonsense about a special court to do corruption cases is not possible. Yes, sir.
So, if I'm coming here, there's a portion of that Section 6 that says such other courts as may be authorized by law.
Yes.
As sub J.
Yes.
Now, could you explain how that plays into this? Because it said it twice in
yes.
J and K. It says
yes.
such other courts as may be authorized by law to exercise jurisdiction at first instance or on appeal on matters.
Yes, absolutely.
You say two times. So
yeah,
how does this play out?
Yes,
Since you've talked about two
yes.
standard courts.
So if the National Assembly were to then create a court and invest with jurisdiction, then that would be such other courts.
Is the CCT not invested with jurisdiction as regards administrative issues?
It is invested with jurisdiction, but it's an inferior court. It didn't make it a superior court. If you look at the act, it didn't say CCT, you're a superior court. So the court-martial established under the Armed Forces Act or the Investments and Securities Tribunal established pursuant to the relevant ISA didn't make them superior courts of record. Therefore, they're inferior courts. And I'm happy you read that. So that's clearly the position.
But let's go back to, you were talking about principles here.
Yes.
Now, there is an infringement, maybe in the order of declaration of assets.
Yes.
There's no attorney general. But the man who brought that matter up is a director in the office of the attorney general.
Yes.
Is he not empowered to do so? Because according to the act, like what he quoted, the act says anyone in the office of the attorney general can bring up these matters. How does that all tie?
It's been decided by Hassan Mr. Tanjira of Kaduna State. If there's no attorney general, no one can take his function. No one can take his function. But that, I think, is a narrower point. I think the larger point that I see, I'm not, as I said, interested one way or the other, what happens to Saraki, quite honestly. But the larger point that I'm keen to point out is not so much the error of the Attorney General in preferring that charge before the CCT, as in whether Saraki himself could actually approach the Federal High Court. Saraki can approach the Federal High Court, as I've said, I think twice or thrice,
yes,
if an error is made by any administrative body, not just the Attorney General, any administrative body, the proper place to go would be the Federal High Court. And the reason is the Federal High Court and the State High Court, the two bulwarks of the Superior Courts of Record, have a special jurisdiction that is of antiquity. We refer to them as the great writs of habeas corpus, certiorari, and all that, prohibition, now merged into one to be called judicial review. So it is to those two courts that a person aggrieved. Let me give you an example. So I'm charged by the police, taken to the police station, brought out on bail, then asked to appear in the High Court on any particular day, and charged with XYZ. I haven't made my statement. I haven't received proof of service. Where do I go? Do I go before that court to answer a plea? Or do I go to another judge to say, not that that court cannot look at the case, but that the manner in which the charge has been preferred by the State Attorney General is unconstitutional? That's what I think Saraki has done.